Well, let me first thank Mike and Mike for inviting me, and thank David for the thoughtful and provocative paper, which I think in an important way delves into a part of constitutional history which is quite underdeveloped in the literature in this field, and which at least potentially could yield information, insights that have important implications for historical understanding and potentially, depending on one's approach, to contemporary constitutional law. I also appreciate the fact that he was responding in some respects to an article that myself and my colleague Dan Holzapfel have written together. I thought I'd begin by saying a few more words about, I think, what in some sense the claims that David is responding to, and then to address his paper in particular. So the overarching, very briefly, but the overarching framework, I suppose, that Holzapfel and I were proposing is to reorient the way we understand the founding, to place it in an internationalist perspective rather than in the traditional conventional nationalist perspective, and seeing it as a highly cosmopolitan document, as evidenced in part by the prominent status that international law has and plays in various respects in the Constitution. There are a number of different themes and claims that are in the paper. One claim that the fundamental aims of the American Revolution were, of course, first of all, to withdraw the colonies from their subordinate position in the British Empire, and then secondly, and equally importantly, to achieve independence and then integration into the system, the European system of so-called civilized states, on an equal footing with the established sovereigns of Europe. And another theme, that the major constitutional, perhaps small c or combination of capital C, small c, constitutional documents of the American Revolution, in particular the Declaration of Independence, the Articles of Confederation, and the so-called model treaty that John Adams largely drafted, and which was to be the foundation for American foreign relations. That all of these documents were written with an international audience, primarily in many respects in mind, and were aimed at trying to advance the cause of attaining international recognition. They succeeded, in combination with other factors, in achieving recognition. Initially, the 1778 treaties with France, the American alliance with France, and then even more importantly, the Treaty of Paris, 1783-84, that ended the Revolutionary War and recognized the United States as a nation. So recognition, in a sense, was achieved. On the other hand, what quickly emerged was that recognition was highly fragile, it was partial, it was defeasible, and that the structure of the Confederation was such that it was enabling, encouraging the states to act in ways which were pervasively in violation of international law, the law of nations, and treaties of the United States, and that was endangering the capacity of the new nation to actually achieve recognition on an equal footing. It was this that was one of the primary motivations for the constitutional reform, for the Philadelphia Convention, and so on, correcting these problems. And it partly helps explain why international law plays such a pervasive role within the constitutional text. One of the lessons that was a critical lesson learned from the Confederation experience, it goes beyond, I think, what I think David was suggesting, which was a recognition of the need for centralizing foreign affairs powers in order to bring the states to heel, to make them comply with international law. That, of course, was a hugely important task. But the diagnosis of the leading Federalists, Madison among them, penetrated much more deeply and began to understand or to theorize about the dangers of the incompatibility, in some respects, of the Republican experiment, of republicanism, unmediated by constitutional mechanisms of various kinds, to ensure compliance with international obligations and the ability of the country to act within the international system as a, quote, civilized state. Okay, and then I guess finally, as David alluded to, that the founding generation, the Muggies among them, many of the leading framers, held the law of nations in very high regard, shall we say. And that was on instrumental grounds, of course, as well as philosophical, existential, identitarian, social, personal grounds as well. So we explore all of those in favor of an argument about constitutional commitment, as David suggests. Now, David says, well, wait a minute, not so fast. Maybe this constitutional commitment, maybe the commitment of the Federalists is overstated here. And maybe the reason it's overstated is that scholars are being misled by the vitriolic statements condemning violations of international law by the states, and into thinking that implied a broader commitment than was actually the case to upholding international law. And he doubts whether or not, in fact, that commitment was there when it came to the federal authority rather than to state authority. And in order to establish this point, he very, I think, very insightfully realizes it would be interesting to see how did the federal government or the federal authorities, confederal authorities during the Articles period, what was their attitude about international law? Did they violate treaties and the law of nations? If they did, what were the consequences? What kind of reaction was there? And the deep point he wants to make is that, in fact, they did violate international law, A, and B, that it was widely acquiesced in or accepted, and it was not a matter of criticism or concern during the Constitutional Convention, and therefore yielding the inference that their constitutional commitment is doubtful. So there are a number of things going on in David's paper. One of them is the claim that the Confederation actually they violated international law. That's, I suppose, the most critical claim. A second is that some leading diplomats, prominent Federalists, tended to take or sometimes took positions on the law of nations and treaties that were highly self-interested, maybe dubious interpretations of U.S. rights and obligations under existing international commitments. And third, that leading Federalists, when they justified talked about the importance of compliance with international law, often cited instrumental reasons, concerns about the giving just causes of war and the weakness and position of the vulnerable position of the United States, not necessarily only moralized kinds of statements about international law. All right. Well, so this is all good so far as it goes, and I think the deep questions for me about the paper are methodological. Whether or not the evidence that David has brought to bear actually establishes the claims that he's making. You might ask two methodological questions. One is, does he present evidence, for example, that the Confederation actually violated international law? And secondly, is that kind of evidence actually evidence for the ultimate conclusion he wants to reach, which is that the framers of the Constitution would have wanted to have discretion in the federal authority to depart from international law. And I think the answer to the question is that there are serious methodological problems that have not yet been addressed in the paper. So it turns out, as to the question of whether the Confederation violated international law, I think David only claims, actually, on careful reading, one kind of violation of what he calls the mandatory ratification rule. But in fact, for lack of time, it's going to be difficult to go into the details, and a lot of this is in the details. That's sort of the whole methodological point, is it's extremely difficult to adjudicate whether or not particular acts were in violation of international law or not international law from our vantage point. These are complicated questions sometimes. In this case, I don't think it's a complicated question. I don't think there was, it's not that there wasn't a rule of mandatory ratification. The question is what was the nature of the rule? And what the Confederation Congress did was it departed, actually quite minimally, from the traditional rule, or the traditional practice, really, that when a minister was given a full powers to negotiate a treaty, that in the full powers was a promise by the sovereign to ratify any treaty that the minister signed, so long as the treaty was within the instructions that the minister had been given by the sovereign. What the Confederation Congress did was not violate that rule. but to change the practice. It began to change the practice, a practice which would then become much more common internationally afterwards. And the change was to put it in a provision into the full powers which said, not that there would be a promise to ratify, but that ratification would be subject to further discretionary decision of the Congress. In no case did the Congress, in most of the full powers that were given when treaties were negotiated, in fact, they did always ratify those. In fact, I think they ratified all the treaties that were put before them. And even in cases where there was enormous opposition and quite intense antagonism to particular treaties, David discusses the Consular Convention with France, which is the most important example. The Confederation and the leading figures in the Confederation all felt that they were compelled ultimately to ratify it because of the rule of international law, that when they gave a full power without this reservation, they had to do it. Second methodological point is, David doesn't present any evidence that any other country accused or charged the United States by engaging in this practice with violating international law. So the judgment that it was a violation of international law is David's judgment, but not the judgment of the other parties who were relevant, or at least there's no evidence of the other parties making a complaint. Nor is there any evidence that the US, the Congress, or the diplomats in the United States believed that there was anything inconsistent with what they were doing with international law. There's no mention of a problem with this practice under international law, but a decision to go forward in any case. Now, I think that's a pervasive feature of the paper, is that it requires something more. We need to go deeper into the sources before we can actually make the kinds of claims that are being made. Now, the second point, just briefly, is even if it were true that there was a violation of international law in this practice of not engaging in mandatory ratification, or at least not including this disclaimer of mandatory ratification in the full powers, that wouldn't establish necessarily the ultimate claim that David's making, because in order for that claim to have salience, it had to have been that there was that someone recognized somewhere that the Confederation was acting in violation of international law. The fact that there was no comment on it during, say, the ratification debates only could be meaningful if, in fact, it was agreed by anyone, if it was thought by anyone that, in fact, they had violated the international law. Now, even if they had violated international law, there's no evidence that anyone thought that they had violated international law, and therefore it wasn't a subject of comment. So I'll stop my comments here.
All right, thanks very much. You've reserved some brief time for rebuttal.
Okay, great, thank you. And thank you, David. Let me first comment on a couple of points from David's paper. One of the interesting themes in that paper, as he mentioned, is that there was concern for republicanism, or at least an unrestrained republicanism that threatened violation of international law. One of the interesting things that I observe is that the response, again, was structural. So while David's thesis is that there's sort of a substantive constitutional commitment to violation of international law, the response to the threats of republicanism were procedural, as he points out, sort of efforts to prevent the populace or the House with its many representatives from having a role in some of these foreign relations questions. And so, again, the response was not a absolute commitment or committing the national government absolutely to compliance with international law. It was the adoption of structures that would tend toward compliance with international law, but certainly not mandate it. I think it's also true that the framers held international law in high regard. I don't see these statements as complete cheap talk or completely deceptive, but I do see the statements yielding to national interest in actual practice. And I think those are compatible, right? A sense of general commitment that softens when we're in specific situations. As to the methodology, I think there's a lot there. And I think it is difficult to establish that a number of these things were actual violations of international law. More so, I feel like, in the treaty context than the law of nations context. And certainly my claim would be stronger if I could establish that these treaty interpretations were in fact clear violations. But I think it's still probative if they were simply sort of aggressive, self-interested interpretations of the treaty, whether or not they crossed the line to violation or not. I do think, though, I disagree that the departure from the practice of mandatory ratification does not reflect a violation of the law of nations, because this wasn't just a practice. It was based on an agency norm that the treaty negotiator was the agent of the sovereign, and so the practice of ratification was the practice of ratifying that the agent had authority to do this, not a review of the substance of what the agent negotiated. And I think Congress turned it in to this other principle and did so quite deliberately. I also think there is evidence that other countries responded that this was a departure from international law. And in fact, you see the United States responding to other countries in situations where other countries had not in the full power departed from this practice, insisting that they ratify, even after the United States had departed from mandatory ratification. And it's not until, I think, certainly into the 1800s, right, when you stop seeing countries complain about this practice. And so I think there is certainly evidence of resistance to this change. I think there's also evidence of resistance, at least, to some of these treaty interpretations. I think of the fisheries example, where the United States tried to argue that France's exclusive rights to the Newfoundland fisheries were protected as long as the United States did not interfere with their exclusive rights or sort of bother them as they exercise their exclusive rights. So we'll go ahead and fish there, and as long as we don't bother you in the exercise of your exclusive rights, right, we're acting consistent with our treaty obligations, which of course is not inconsistent with the notion of exclusive rights. So we get examples like that where there is pushback on the interpretation. The second methodological point, even if there is a violation, it needs to be intentional, or at least members of the national government needed to be aware that this was happening. Again, I think this pushback from these other countries makes them aware. And I think just reading the history, right, this all looks very intentional. This all looks very deliberate. It's not sort of a, oops, we made a mistake and read this treaty wrong. And certainly some of the response of the national actors when a problem is brought to their attention, say with the negotiations with Britain, in tension with our obligations to France, there are those who express concern about what we've done, but there are others who think of our negotiators as heroes, or at least justified in departing from our treaty obligations with France.